Welcome to our election petition update. Today, the 7-member panel hearing Mr. Mahama's election petition will rule on the matter of whether or not the EC, as respondents, can elect to close its case without putting its witness, Jin Mensah, in the witness box. My name is Mama Vio Wusuabuaje. Our update is in association with Petrosol Coa Mixture and DBS Roofing. We'll take you live now to the Supreme Court.
My learned colleagues, Frank Davis, Kweku Estrefi, and Yao Pong.
Are they your learned colleagues or your learned friends?
As your lordship pleases.
No, let me know. What's the right terminology? Is it learned colleague when you are announcing?
Learned friends, my lord.
This is the ruling of the court. The fundamental issue raised in this objection is whether or not the first and second respondents in this petition could be compelled by this court to give evidence, notwithstanding their express indication to the court that they do not intend to do so. This petition was brought under Article 64, Clause 1 of the 1992 Constitution. The petition seeks to challenge the validity of the election of the President in the 2020 presidential elections conducted on the 7th December 2020. At the close of the petitioner's case, counsel for first respondent announced to the court that the first respondent does not intend to adduce any evidence in the case and therefore wanted its case closed. Counsel for second respondent associated himself with the position taken by the first respondent and reiterated that the second respondent would also close his case because he was not adducing any evidence. Both counsel submitted that having regard to the evidence led by the petitioner through his witnesses, they did not deem it necessary to adduce any evidence in the matter. The two counsel relied on Order 36 Rule 4.3 of the High Court Civil Procedure Rule CR 47 and Order 38 Rule 3E Sub Rule 1 and 5 of CI 47 as amended by the High Court Civil Procedure Amendment Rules 2014 CI 87. Learned counsel for the petitioner has opposed the position taken by the respondent and argued that the respondents, especially the first respondent, cannot refuse to adduce evidence in this petition. The grounds upon which counsel for the petitioner opposed the petitioner's decision not to adduce evidence are that they have both elected to adduce, respondent's decision not to adduce evidence are that they have both elected to adduce evidence in that they have filed and served witness statements as ordered by the court. Counsel for the petitioner argued further that the first respondent in particular, besides filing an answer to the petition, has also specifically deposed to an affidavit in opposition to an application to serve interlocutories in which the chairperson indicated her availability for cross-examination. Finally, it was contended by counsel for the petitioner that the first respondent chairperson performs a very important constitutional function and as such must be made to adduce evidence in his petition to account for his stewardship to the people of Ghana. In their submission before the court, counsel for respondent, particularly for the first respondent, sought to rely on Order 36 Rule 4 Sub Rule 3 of CR 47 and Order 38 Rule 8E of CR 87. We have carefully examined the above rules and our opinion that the provision that is relevant in the determination of this issue is Order 38 Rule 3E of CI 87, which specifically deals with the use of witness statements in civil trials. We deem this rule to be crucial in view of the position taken by counsel for the petitioner, among others, that the filing and service of a witness statement connotes that a party has elected to adduce evidence at the trial. We recall that the filing and service of witness statement in this case was in compliance with an order of this court as part of the pre-trial protocols before trial commenced. It is also an undisputed fact that a defendant in a case can elect whether or not to adduce evidence at the close of plaintiff's case when such a defendant is called upon by the court to open his or her defense. We are of the considered opinion that it would be wrong in law to hold that a party is deemed to have elected to adduce evidence as soon as that party files and serves a witness statement in compliance with the court order. To hold so would mean that once a party files and serves a witness statement, that party mandatorily has to mount the witness box and adduce evidence at the trial. This position is not borne out of the rules. Indeed, Order 38 Rule 3E sub Rule 5 clearly provides otherwise as follows, quote, if a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence, end of quote. The above rule implies that when a witness statement is filed and served, the party who files it may choose not to give evidence at the trial. The principle is the same in viva voce evidence, where a party or witness who mounts the witness box testifies in chief and fails to turn up for cross-examination. Such a witness cannot be compelled by the court to appear for cross-examination. He suffers the penalty of the evidence being expunged from the record. This is exactly the position the respondents have taken in this petition, where both respondents have decided not to adduce evidence even though they have filed and served witness statements. The above rule also points to the fact that a witness statement filed and served does not constitute evidence in law till the author of the statement mounts the witness box, takes the oath, and prays that the witness statement be adopted as evidence in chief pursuant to Order 38 Rule 3E sub Rule 2, which provides thus, quote, where a witness is called to give oral evidence under sub Rule 1, the witness statement of that witness shall stand as the evidence in chief of that witness unless the court otherwise orders, end of quote. In view of the clear provisions of the rules referred to above, we do not agree with the submission of counsel for the petitioner that when, as in this case, an answer to the petition was filed at the pleading stage and witness statement filed, the respondents had elected to adduce evidence at the trial. We are also of the opinion that the filing of affidavit in interlocutory applications with the averment that the deponent will be available for cross-examination does not make the deponent compellable to adduce evidence at the trial. Counsel for the petitioner has argued that because the first respondent performs a very important constitutional duty when it is sued in an action such as this case, different rules should be applied. However, counsel failed to refer us to any provision of the 1992 Constitution or any statute which required that the first respondent, being a constitutional body, should be subjected to different rules of the court, and our own industry did not unearth any such authority. The law is that parties before this court must always comply with the no rules of procedure and settled practice regulating the jurisdiction of this court, regardless of the nature of the case. See upon versus Attorney General and others, 1999-2002 Ghana Report 402. The first respondent is not subject to any different rules of procedure because it is a constitutional body. The evidential burden imposed by law on a person seeking to challenge a presidential election result has been settled by this court in the 2013 election petition case entitled Akufo-Addo and others versus Mahama and another, 2013 Supreme Court of Ghana Law Report, Special Edition, page 73. Thank you. After citing with approval several decisions of courts in some Commonwealth countries, notably Nigeria, Uganda, Kenya, and Canada, Edina JSC concluded at page 218, thus, quote, accordingly, the petitioner The petitioners bear the burden of proof to establish not only that there were violations, omissions, malpractices, and irregularities in the conduct of the presidential election held on 7th and 8th December 2012, but also that the said violations, omissions, malpractices, and irregularities, if any, affected the result of the election. It is after the petitioners have established the foregoing that the burden shifts to the respondent to establish that the results were not affected. The threshold of proof should, in principle, be above the balance of probability. We have started doing that JSC's dictum to drive home the legal proposition that the petitioner in an election dispute stands or falls on the strength of his or her own case and never on the weakness or otherwise of the evidence of the respondents. Counsel for the petitioner cited to us the case of Smala Biabial versus Ademu Dramani and Attorney General number 4, 2012, One Supreme Court of Ghana Law Report, page 374, in which this court ordered a party to adduce evidence because that party had already adduced evidence in the form of an affidavit. That case is distinct from what is before us now, and it must be read in its context relative to the facts before the court then. In that case, this court was dealing with the submission of no case in a trial admitting affidavit evidence, unlike the current petition, where this court is dealing with witness statements which are unsworn and are not yet evidence. Indeed, the distinction between that case and the current case is clearly demonstrated in the ruling of Dr. Datiban JSC, who delivered the ruling of the court. At page 357 of the report, the learned jurist delivered himself as follows, quote, "It is the unanimous view of this court that the first defendant, Ademu Dramani, should be called upon to open his defense in the interest of justice. This case does not have the ordinary characteristics of a trial," said the High Court. "The procedure before this court is such that before the commencement of oral testimony in this case, the first defendant had already put matters in evidence by affidavit. In this circumstance, it is artificial and hardly sustainable to disregard the evidence already adduced by the affidavit of the first defendant and proceed to an assessment of a no-case submission made on his behalf, as if the evidence on record is that of the plaintiff." End of quote. The distinction here is that in the petition before us, the first respondent has not put before us any evidence in the form of an affidavit or otherwise. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interlocutory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compare the first respondent to mount the witness box to be cross-examined. The Smala Biabial case is clearly distinguishable on the facts and the law. Now, besides the rules referred to in this ruling, we take notice of the well-settled practice that a plaintiff in a case has a right, that a defendant in a case has a right not to adduce evidence after the close of a plaintiff's case. This right, which originates from the common law, has been incorporated into several trials in our jurisdiction through case law and has been applied in several cases in our courts. The general principle of law is that a party cannot be compelled to adduce evidence in a trial. In this direction, we intend to refer to some cases on this principle of law. In Yamecha vs. Ansan, 1989-92 Ghana Law Report, page 152, Court of Appeal, and PRJ, as it then was, delivered at page 155, that's, quote, "The plaintiff contended that since the first defendant did not give evidence, judgment should have been entered against him. I do not agree. A party to an action need not give evidence himself. A party to an action needs not give evidence himself. Provided he can adduce evidence of some sort from other sources, the court would have to look at that evidence in considering the totality of the evidence before it." In Baron versus Labi, 1962, one Ghana Report 168, in the practice note, Olenuji, as he then was, delivered himself as follows, quote, "A party to a suit is not bound to give evidence, and the court cannot compel him to give evidence if he does not want to. And if a party, having gone into the witness box and sworn or affirmed, elects to give no evidence, his opponent is not obliged to cross-examine him. This procedure, therefore, is not irregular and cannot vitiate the proceedings and the judgment in the case." End of quote. In Tai and another versus FIBA International, 2017-2018, 2 Supreme Court Ghana Law Report, 906 at 919, Poorman JSC opined as follows, quote, "It must be remembered that the fact that a defendant does not appear to contest a case does not mean that the plaintiff will be granted all that he asks for by the court. The rule in civil cases is that he who alleges must prove on the balance of probabilities, and the burden is not lightened by the absence of the defendant at the trial. The absence of the defendant will aid the plaintiff only where he introduces sufficient evidence to establish a prima facie case of entitlement to his claim." End of quote. In Ama versus Hydroform Estate Limited, 2013-2014, 2 Supreme Court of Ghana Law Report, 1551 at 1567, which was cited to us by Counsel for Respondent Benny JSC, held as, quote, "A court has no duty to call upon any party to testify in the case. The court acts as an umpire and only hears such evidence as the parties will prefer. Whether the parties will testify or not is none of the court's business. Indeed, a court to insist that the party should testify will amount to the judge descending into the arena of conflict. After determining the tribal issues, the trial court leaves the field clear for the parties themselves to decide who will testify. We know of no law or rule which entitles a court to call upon a party to testify in the action. If such a law or rule does, we would venture to say that it is inapplicable under legal dispensation." End of quote. Finally, we refer to the case of the Society of Lawyers versus Sir William Otto Jeffrey, BT 2000, Queensbend Division Commercial Court, which on the facts is similar in terms of procedure with the current case before us, and cited by counsel for the second respondent. In that case, all the witnesses had served their witness statements in accordance with pre-trial directions under the civil procedural rules, but lawyers had decided not to call them to testify at the trial. An application was made to the court for an order requiring the opposing party to call the witnesses at the trial so that the applicant could cross-examine them. Creswell J. held that in civil proceedings, the trial judge had no power to dictate to a litigant what evidence he or she should retender. There was no obligation to call witnesses. It was counsel's duty to decide what evidence was called and the order in which it was called. The instant court had no jurisdiction to make the order sought. The law is therefore settled that a party will not be compelled to enter the witness box and testify in support of his or her case. It is a risk parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Laws case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case, like this petition, also deals with witnesses who have served witness statements and have decided not to give evidence to be cross-examined. We are mandated to state that our jurisdiction invoked in this election petition is a limited jurisdiction clearly circumscribed by law. We do not intend to extend our mandate beyond what the law requires of us in such petitions brought under Article 64, Clause 1, challenging the validity of the election of a president. Simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondent to enter the witness box to be cross-examined. Accordingly, we hereby overrule the objection raised by counsel for the petitioner against the decision of the respondents declining to adduce evidence in this petition.
As the court pleases. We are most grateful to the court.
And also, we are most grateful.
Please, you will rise for about 20 minutes.
My Lord,
yes.
Respectfully, before you rise, I think I ought to notify your Lordship that we will now seek your Lordship's permission to reopen our case in order to have a subpoena on the chairperson of the Electoral Commission. Now, my Lords, we know that we can issue a subpoena without leave, but since we have closed our case on the assumption that she would be, so we intend to file a formal motion we intend to file a formal motion.
Counsel, it's a court of record, so like you rightly pointed out, you come by your formal motion, you'll be heard.
Very well.
Yes, but you'll come back and give directions for the further trial.
All right, so the 7-member panel has just delivered their decision on the objection raised by Mr. Chikata on Tuesday on the issue of whether or not to get the EC chairperson, Jean Mensah, to be in the witness box to be cross-examined. The 7-member panel has just decided on that case. They have overruled that objection. They say a court cannot compel a witness to mount the witness box, and they've cited many cases in justifying that decision. They are on a 20-minute break. They would return, they say, to give further direction for this trial. But just before, this very early session ended, Mr. Chikata also tried to get permission to file a motion to compel the EC chairperson, if you like, to be in the witness box to give evidence. He has informed the court that he will file a formal motion, and the court said that he could go ahead and do that and he will be heard. But they will return in the next 20 minutes to give direction on this election petition. If you're just joining us, you probably may have missed the ruling because it was delivered quite quickly. Court was ready a little after 9:30, and before 10, they have delivered that ruling. This is to the effect that the court will not insist that the Electoral Commission puts forward its witness, Jean Mensah, in the witness box to be cross-examined. Remember last Tuesday, Chacha Chikata raised the objection, saying that Jean Mensah had made representations that suggest that she intends to be cross-examined. Therefore, the Electoral Commission ought to be stopped from electing not to put her in the witness box. Chachu also said that there was a constitutional duty, and that the constitutionality of Jean Mensah's declaration on the 9th of December essentially is at the heart of this case. That's the election not to give testimony is an affront to justice and must not be countenanced. Court absolutely disagreed with Mr. Chikata on all these issues. He also said the decision by the justices today, of course, would determine where the case travels to next. And he's just made that indication that they want to subpoena Electoral Commission Chairperson Jean Mensah to get into the witness box to give some testimonies. There will be a formal request, he says. The court says if you put it through, we will absolutely consider that request. But they will give direction to where this whole petition travels to next when they return to conclude this morning's session. It sounds like we're drawing to a close on this matter for the Electoral Commission Chairperson to be in the box or not. So there's another leg to what we have just heard this morning. But I just quickly want to remind you of some of the rulings by this court so far on this particular petition. In the first issue was the unanimous decision that allowed the petitioner, Mr. Mohammed's lawyers, to make some corrections, not on the substantive matter, but some corrections with this petition. And then unanimously, they also dismissed the request for some 12 questions to be served on the Electoral Commission. And then there was the review of this decision by a reconstituted panel, also unanimously dismissing the request. Then we'll come to another unanimous decision, which was portions of the petitioner's witness statement, which were deleted. There was also the unanimous refusal of a request by the petitioner for document to be inspected. A motion to admit facts also refused. They again struck out 5 paragraphs of the petitioner's third witness statement. That's Rojo Metal-Nunu. He had some 32 paragraphs, but 5 of those paragraphs deleted. And now this fresh ruling on the objection because the Electoral Commission and the second respondent in this case, Mr. Akufo-Addo's lawyers, had elected that they would not let their witnesses, i.e. Jean Mensah and Peter Malcolmeno, to mount the witness box to give evidence. They had also closed their cases after the petitioner announced that his case, after the third witness had given testimony, that they had also closed their case. This issue was whether or not the court could compel the Electoral Commission to put up their witness to be cross-examined, and the court has just decided this morning, just minutes ago, that it is not, or it cannot make that decision in terms of compel a witness of a party to be in the witness box. So this is where we are, but at the end of everything that you've heard, we're talking about the issues here. So this is what the court would arrive at. We also keep asking the questions, if the case is going to be decided on what the court has currently, then they have to answer the question of if there are any legal grounds for the petition. Now, some people have said, well, because the case has traveled this far, it definitely means that there are legal grounds, there are constitutional matters in this to be dealt with. But we wait to see the final judgment of the court. They are also to determine whether or not Mr. Akufo-Addo obtained more than 50% of the total valid votes cast, whether or not Mr. Akufo-Addo still got more than 50% of the total valid vote cast with or without the Techiman South constituency presidential election results, and then whether or not the 9th December 2020 declaration met the 50% plus threshold set for a person to be declared as winner. And the final one is whether or not the alleged vote padding and other errors complained of by Mr. Mahama affected the outcome of the presidential election result of 2020. Kojian Singh has just joined me. Yeah, just when the court returned today to deliver its ruling.
Indeed, and quite a ruling. I mean, they spoke for a good 18, 20 minutes explaining this ruling. And they sought to really lay the foundation of the processes they went through to arrive at their ruling. They first explained that, look, for them, the issue was whether or not a respondent can be compelled to give evidence. For them, that was it. So they started to walk through their thought processes. They said, look, when you provide a witness statement, it is not yet evidence until you, the witness, are seated and have, taken the oath and then indicated that your testimony will rely on that witness statement. That is the only time when the witness statement is admissible, as evidence. And then they talked about the fact that, look, if in your deposition, when you were providing your, when you saw an affidavit and you were providing your deposition, you said that, oh, well, you don't think there should be interrogatories because you will answer questions, under cross-examination. The fact that you have made that statement doesn't make you now a compellable witness, that the court must now compel you to testify because you said that you will answer questions, in cross-examination. And then they went on to talk about the fact that they searched through the law, they searched the Constitution to see if the EC chairperson, as an individual, is subject to different laws, when it comes to the rules of procedure and settled practice, whether because she is the EC chairperson, the rules should be applied differently to her. And they found nothing in the Constitution that said that. And then they said, look, in the end, as a petitioner, your case is your case, not evidence from the respondent. So you must come along with enough information that you believe you would have made your case by the time you rest. So your case ought not depend on the respondent's evidence. Your own evidence should be what drives your case. And then they talked about the Sakande case and said that it is distinct from what is happening presently. And then they concluded. They said, look, the court cannot compel a party to give evidence. There is no such law that empowers it to compel a witness to testify. Now, I think it's important to clarify at this point. They are talking about a witness that has been offered by a party in the case. If a party offers a witness and then says, I no longer wish to place this, to use this witness, the court feels that they do not have the power to compel that witness to be seated on the stand. That does not mean that the court doesn't have the power to compel people to testify. It's called a subpoena. The court can definitely subpoena any individual in this country, subject to our laws, to testify. And in fact, Mr. Chikata indicated at the end of that session that he intends to make a formal application for exactly that to be done.
Yeah.
So it looks like it's not over.
Exactly. But, because he also closed his case after Roger Metal Nunu's, testimony, he now has to reopen that case. And then he has to make, as you said, a formal request. But the court has already indicated through its presiding judge, the Chief Justice, Enini Yeboah, that they are open to hearing him when he makes that when he puts in that formal application. But are they coming back to give a date for the judgment? Because it sounds like we're almost, in the absence of any other request from the petitioner's side, this sounds like we're almost wrapping up on this case.
Well, I suppose it would depend on the arguments made by Mr. Chikata. Now that the court has said they are open to hearing that argument, it will depend on how that argument goes. If indeed that argument requires for the Supreme Court to make sanction a subpoena to call Madam Jean Mensah to testify, then we're not done. But if that argument does not, Mr. Chikata's argument does not convince the court, then you're right, we're near the end. And we'll then be looking to judgments.
Just want to say our updates is in association with Petrosol, DBS Roofing, and Koa Mixture. We're just talking about the Election 2020 petition and the court's ruling this morning. In some few minutes, the court will share with us how they intend moving forward. Would it be a date for judgment? Would it be an adjournment of the case? Waiting to hear the arguments that Mr. Chikata will put. Let's go back to the court now and join our colleague, Kweku Asante. Kweku, if you can hear me, tell us the mood in court today, especially after that ruling.
Right. So as soon as the court rendered this unanimous decision, obviously the first and second respondents said that they were happy at the decision of the court to as it were overruled the objection by Mr. Petitioner on behalf of the petitioner. But then as soon as they did that, I just as you saw in the shot, Justice Chikata got on his feet and said that they were seeking the leave of the court to reopen their case.
To reopen their case and issue a subpoena to the Electoral Commission. And so the court will be back in 20 minutes, not necessarily to decide on the application to subpoena or to reopen the case, but to give a ruling on questions on addresses and also the date for a judgment. Because as of now, this means that the case has come to an end because the petitioner has closed his case, as well as the first and second respondents have all closed their case. And so it's up to the decision of the court to make further directions and when it will give a ruling on this. But as soon as the court gave its decision and rose, I saw Mr. Eduji Tamaklo run out of court to a waiting car, which just sped off from the court. And so what I'm sensing is Mr. Eduji Tamaklo is going to work on the application that will be seeking to subpoena Madam Jean Mensah to testify. But the mood in court is in such a way that there's the side of the petitioner where the NDC the legal representatives as well as their national officers are sitting. But not so good. You see them chit-chatting and trying to talk to each other and have an idea as to what next decision they will be taking. But so far, it is not so clear yet, because in 20 minutes time when the court comes, we'll be giving directions in terms of how this case is going to move, Mamavi.
All right, Kweku, we'll come back to you. We have just less than 20 minutes and we don't want to miss anything. So we'll leave you so that you can settle back in that courtroom. We wait to hear the direction that the court would give on this matter. Now, Petrosol, clean fuel in full quantity is always a delightful experience. DBS Roofing and Koa Mixture. they're bringing us this update here on Joy News. Kojo Yankson, you keep looking at the reasoning that they gave for this ruling this morning. What's on your mind?
I'm thinking of a couple of things, in the processes that they went through to arrive at their decision. I was interested in the fact that they actually went as far as looking into the Constitution to see if they will find any law that says that this particular individual, by nature of her job as EC chair, should be subject to different rules than other people when it comes to procedure in court. They deliberately went to the Constitution to look that up. And you see that was in response to one of the arguments made by Mr. Chikata. And you remember that he was quite vociferous, talking about the fact that we are dealing with an individual whose position is unique as the returning officer in this election, as the individual whose declarations have led the petitioner to the Supreme Court. He felt, and he was, quite convinced himself in his argument, that the rules ought not be the same way that they are for other witnesses. But the Supreme Court said they went and looked, and they found nothing to support that argument. I just found it interesting that it's not a matter of the judges relying on their own knowledge and understanding of the rules and simply, making a ruling on that. That might have satisfied some people anyway, but they go further. To see what is provided for.
Let's engage Samson Ladia Yanini on this matter. Samson, a very good morning to you. Thank you so much for joining us. You had indicated in the past that this bridge where we had got into, this was a very difficult task for Mr. Chikata. We see that the court has applied the strict rules. Some had argued that this is the Supreme Court's, they can make public interest decisions, so they could have gone the other way, but they stuck to the rules. Are you surprised?
How would I be surprised about something I said is a standard? Look, I have said, and I remain at that place by virtue of what I have witnessed in my practice over the years. At least a practice in 10 years. I was actually praying for the opportunity to read a reasoned dissent. I mean, at least one of them dissenting and not making it a unanimous decision. Which dissent could have provoked a start to a judicial attitude towards potential caveated change in the rules in treatment of public institutions and get check this. Even though, for me, it is difficult to think that it makes legal sense or even common sense to compel a witness to adduce evidence when they elect otherwise. As I told you the last time, this is settled, and it is what we apply all the time. Whether we should make an exception of it because there is a public institution that is being dealt with. It's something I'm still struggling to think about properly. Therefore, I was hoping that maybe one of the judges would have helped me to think about it by dissenting and then giving us a lot of room and reason to think along that dissent. Look, this morning, there's a matter I am attending to in court. And I have been asking myself and praying that the defendants, there are 3 defendants, 2 institutions, 1 individual. I have been praying that they will come and say, look, at this stage, we don't want to, read any evidence. And I would have been so joyous because with or without them, my case is made. And that's the principle of law. You must not need the other to be able to make your case. And that's the point I have been making. Once you put your case in the courtroom, you must have made it. So to seek to weaken the other person's case before before your case is made, I have said it's a very difficult thing to think about, and I noted that he has quite a hurdle. So this was not unexpected, especially that the case that preceded this one, the same Supreme Court and 4 of the judges who are on this case were in that case, and they held that a witness statement is not evidence unless it has been tendered when the person gets into the box to start relying on it, and evidence is not admitted at pre-trial or case management level, but during cross-examination. That clearly told me that 4 judges in that decision of 5 judges, which was unanimous also, and the decision was actually rendered by the 5th judge, who is not among this panel and whose civil procedure is so solid. All of us as lawyers, unless you are so new, and even if you are new at the law school, you would have been told by somebody to go and sit in Justice Sanko's court. Justice Amadou Sanko's court to just listen for proceedings within the period. At a certain point in time, the courtroom became sort of our second civil procedure class, and we would leave school and go and sit there just to watch how things will go on. He gave that judgment, that ruling, for the entire panel of the 4 who are on this particular panel. So it's not surprising.
Samson, we could have another hurdle here, reopening of a case that has been closed. How difficult of a task is that?
Yeah, it's yet another difficult task, but not unsurmountable, not impossible, because of the circumstances of this case. The circumstances of the natural expectation that the witness was going to get into the box, the circumstances of the natural and prior announced expectation that the witness will be in the box. When the interrogatory were to be answered, the witness said he will be in the box.
How would that, usually, so let's use experience here. We know that the court has announced that it will come back and give directions. What usually would happen at this time? Would we hear that request to apply or that application to reopen the case before they give their direction?
Ask that question again.
I want to know, since the court announced that they would come back and give directions after that ruling, I'm just saying that Chachu's request to reopen, would we see when they come back, when they return, would we see him make that formal request before they go ahead and announce to us the direction that they intend going with the case?
Well, they may ask the party that said it doesn't want to call a witness. The parties that have said they are not calling, they are putting their witnesses in the box to come and make statements, because that's the next stage. If you are not opening your case, then you make a statement. So they may call them to make some formal statement to end their side of the case, and then they may ask all the parties to go and write their written addresses and bring their addresses, and then they may tell us also when they expect to deliver judgment. But all of that does not stop the petitioner from seeking to make any application that it wants to make. The fact that they have given such directions does not mean everything is lost.
What form, Samson, just before we leave, we let you go, what form does the subpoena, how does it come?
How does it come?
Yes. How, so you make a request to the courts, and then I just want you to explain the processes involved, just so we can appreciate.
So there would be a basis for a subpoena. You must convince the court the basis for the subpoena, and the court must agree with you that the basis for you seeking to subpoena a witness is valid. Otherwise, a witness would not be subpoenaed. So, like I said, it's yet another hurdle, particularly that you have closed your case already. You must be given an opportunity to reopen it before that comes in. Then the witness will be subpoenaed. Once the witness is subpoenaed, then that's a clear adverse witness that we treat them, as we say in our parlance, a hostile or adverse witness.
Okay.
Oftentimes, these are witnesses that you would have called yourself, and you would have called them by yourself for your purposes, but you turn them into an adverse witness.
Okay.
Because you're
right.
adverse witness, how you deal with them is without any concession. So
okay.
you are
right.
uncharitable in the manner you speak.
Okay, Samson, I thank you. We have to leave it here and take you back to the Supreme Court.
My Lords, sir, as I indicated, I am aware that your Lordships are seeking to take directions.
Yes.
And because of that, I think I need to make clear what we are in the process of filing in this court. Because I believe it would not be really, it would be useful if your Lordships are aware of that in advance. My Lords, we are applying in the papers that we're in the process of filing, we are applying to reopen our case because we closed our case on the basis of the indications of witnesses that would be heard. We closed our case on that basis. We are applying to reopen our case, and on that basis, we will be issuing a subpoena addressed to the chairperson of the Electoral Commission of Ghana. And we believe that those processes are necessary processes that would have to be heard and determined in this case. We also intend, subject to receiving a copy of the ruling that you delivered this morning, we also intend to apply for review of that ruling. And that application, we believe, would also have to be heard in order. Very well, my Lords, we're drawing your attention to it because we believe your Lordship should take that into account in whatever directions you give. We do not think that it would be appropriate for us to have to be bringing applications for stay of proceedings and so on. I mean, we can do that, but it may be better to avoid going through all those different processes if your Lordships would allow us the opportunity to file and have those processes determined.
With all due respect, we cannot prevent a party from filing processes. When a process is filed, the court will come and hear it. Whether it is review, whether it's stay, whether it's an application to reopen the case or whatever, we will come and hear it. But these are the directions. Yes, by court. By the ruling just read, the respective cases of the first and second respondents are deemed closed. This court hereby orders that the parties hearing should simultaneously file their respective closing addresses or submissions on or before Wednesday, the 17th of February 2021. The petition is hereby adjourned to the 18th of February 2021 for counsel in this petition to highlight on the written addresses or submissions so far for the petition to be adjourned for judgment. So we will come here on the 18th of February. Yes. Yeah.
My Lords, there is also a matter which arose in connection with your issue 2, and I wonder whether that has been resolved. I think we should, as a matter of record, know. My Lords, when we come when?
We are correcting, so it should be whether or not, based on the data contained in the declaration of the first respondent, of, not for, of the second respondent as president-elect, no candidate obtained more than 50%.
Can your lordship go over that again respectfully?
So, whether or not, based on the data contained in the declaration of the first respondent of, not for, of the second respondent as president-elect, no candidate obtained. So it's simply that the for
should be off.
To be off.
That's the only correction.
That is the only
Very
correction.
Well.
All rise.
Okay, so this is where we are. Court just returned to give the direction after that earlier ruling on the fact that they could not compel the first respondent, a party to this petition, to put their witness in the witness box to be cross-examined. They have said that they've ordered the parties to file their written addresses, and that should come in on or before 15th of February. Court has been adjourned to 18th of February where they would hear those addresses. Now, the petitioner's lead counsel, Mr. Chachichikata, has made the court aware of a few things. First of all, he says they will be applying to reopen their case, and they will be also issuing a subpoena addressed to the Electoral Commission chairperson. They intend to apply for a review of this ruling that has been delivered just this morning on the issue of the Electoral Commission's witness, Jane Mensah, being put in the witness box. Remember that this was a unanimous ruling. With this will be similar to the interrogatories, the 12 questions that the petitioner intended to put to the Electoral Commission. That was also a unanimous decision. Remember, there was a review application where 2 justices were added to the 7-member panel, making it 9, and they also dismissed that application in that review. So if they apply again, we will see another panel being reconstituted to determine this matter of a review application on this morning's ruling. So that's where we are. The court says they will allow them to file and have those processes to be determined. But Mr. Chikata also did indicate that they did not want to apply for the court to stay proceedings whilst they put in these applications. We'll try and get something so that something can help us, break all these hard issues that we're hearing this morning in terms of where we are going with this matter down. But Kojiang Singh has also been listening closely and watching. This is all happening. We knew we would get to the end at some point, but it sounds like suddenly a lot is happening today.
Yeah. I mean, Samson said it when he said it's going to be a challenging task to reopen the case. Not impossible, but certainly challenging. I mean, the court has ruled that they consider every case to be closed now, the case of each party to be closed now. And subsequently, they have ordered that all parties submit their final submissions by the I believe the 16th, so that they can adjourn to the 17th, if I've got that correct. And it just raises the issue of how much this court is sticking to. Sorry, they have adjourned to the 18th,
Exactly.
so the submissions must be in by the 17th.
No, before the 15th.
Oh, no, before the 15th.
Yes.
Oh, thank you for that. So the 18th is when the court expects to resume this case. And it just reminds you of the level of adherence to the rules that this particular panel of the Supreme Court is willing to do, or has determined to do. They are not seeking so much to chart new paths, you know, to rewrite or reinterpret any of our laws, which they have every mandate to do. But they are seeking to stick to the letter of so many of our proceedings while they operate. And I don't know whether this is unique. I haven't followed enough Supreme Court cases to know whether it is more likely for them to stick to the existing protocols or to create new, to create new ideas. But okay, so it appears that the 17th is actually the date by which the final submission.
Exactly. Apologies there.
That's okay, no problem. So yeah, I'm just saying, I don't know how unique it is to have a Supreme Court that doesn't want to rewrite or reinvent the wheel, that doesn't want to create new, precedents, that doesn't want to interpret the rules in a way that they consider would be most useful to the people of Ghana. They seem to be quite comfortable with the regulations as they are. They want to stick to them. And then if you want to do something else, whichever path is available to you, that is what you take. So Mr. Chikata now, I suppose, will have to file his appeal for the review and also to reopen the case. Interesting. I wonder what his arguments will be for the reopening of the case.
Well, let's go back to the courts now. Kweku Asante is there. He'll bring us some live reports on the ground. Kweku, this all happened so quickly. What are people saying?
So it is expected that the petitioners who will be addressing us very soon will file the application, which will be seeking to subpoena the Electoral Commission chairperson. That will be before, if the court will grant their leave to reopen their case, because as of the last hearing, they had closed their case, and so as of now, it's up to the court to just receive the written addresses from all parties and then hear them and then make a determination from there. And so, for now, if there are no other applications or motions going forward, then the court is preparing itself to render judgment. But for now, the mood in court, as you would expect, is that the respondents, the first and second respondents, have had a victory in court today because their decision to not allow their witnesses to testify has been granted by the court, as against the objection that was raised by Mr. Secretary for the petitioner. And so I tried to speak to Dr. Dominic Ayini earlier. Of course, they are not so happy about the decision, but they want to come to the table, they want to come to the podium and speak to the media about what the court has decided. But they are yet to come out. But like I told you earlier, the indication I got from one of the NDC lawyers in court was that they were willing to file their subpoena application right now, even before the court ruled, but they could not do so. And they could not do so. And earlier I told you that Mr. Edith Samato had left the court hurriedly in a car that was ready to get sped up to wherever. And so they were willing to file this application to subpoena the Electoral Commission chair, because now that the court has ruled that the laws, existing laws, and all the cases they cited do not allow the court to compel a witness to testify against their own decision, then the only decision for the petitioners to take will be to force the Electoral Commission to come into the court by way of subpoena. And so they are supposed to do so if they are minded to do so. But for now, the court is expected to receive the written addresses of both parties by 17 February 2021, and then we'll proceed to hear that and make a determination. I've just seen Dr. Dominic Ayini walking towards the podium, and so let's say in a minute or two, they will be addressing the media.
Okay, all right, Kweku, we'll let you take your position on that. We will return to you shortly when the team is ready to address the media. Kweku Asante, our colleague, who's at the Supreme Court this morning monitoring events there, and will be bringing us a lot more with that address that we will hear from the petitioner. So according to Kweku, looks like it's the petitioner's side that will be addressing the media first. You'd see, if you're watching us on television, the team is walking, I guess, towards the microphones to deliver that address.
And in a moment, of course, we'll be hearing how they are taking this news. 3 guesses as to how they're taking it. No doubt there won't be a lot of joy at the returning ruling of the Supreme Court. But we would be interested to understand what their strategy is going forward, and I'm sure Madam Marietta will eloquently explain that to our understanding.
We'll take you back now and listen in.
Are you ready? Are you ready? Okay. Good morning, ladies and gentlemen. Well, I don't see any ladies. Okay, so good morning, gentlemen. I believe you all followed the proceedings today, and of course, starting from Monday. On Monday, the petitioner closed his case after calling 3 witnesses. After closing his case, the respondents, per their counsel, informed the court that they had elected not to mount the witness box. What this means is that, or what that meant was that the chairperson, Jean Mensah, and the representative of the second respondent, Mr. McMenu, were not going to mount the witness box to testify and be cross-examined by counsel for the petitioner, Mr. Chikata. You'll all recollect that they had filed witness statements in the case. So naturally, counsel for the petitioner opposed this request or application by the respondents on the grounds that not only had they filed the witness statement, but by 2 affidavits by which they opposed our request for them to answer interrogatories and for them to produce certain documents. The chairperson particularly had said that she would be available for cross-examination. Now, the petitioner's point was that under the specific rule, Order 36, they had elected by this particular conduct to adduce evidence in court, and therefore it was no longer open to them to tell the court that they were not going to give evidence. Of course, on Monday you heard the superior compelling arguments by Mr. Chikata, and of course you heard the wishy-washy, insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important. There are important lessons to be learned from this. Now we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
Yes, ma'am.
Counsel for Petitioner also announced that he will also file an application for review of the decision of the court. So that's 2 applications he'll be filing.
I'm sorry, review of the decision we had today.
Today's decision
Okay.
he will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as superior the argument made by Mr. Chikata against the application, and as wishy-washy the argument made by lawyers for the respondents.
Yes.
How would you, in that position, describe the ruling that we have from the court today?
The ruling is the decision of the Supreme Court of Ghana. We have nothing to do but to accept it. We disagree with the decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties
18th. Okay.
You file by 17th and your addresses, and the court comes back on the 18th. We know, as you said, you made an application or filing, you are going to file an application for a review, file another application for your case to be reopened. When you write your addresses and it's brought before the court, what becomes of these two applications, especially the one for you to reopen your case? Because then by the time your addresses would already be provided to the court. And what's next is that the court gives directions or a date for ruling.
Well, you heard his lordship. He said that nobody can stop us from filing an application. When an application is filed by a party, the court will deal with that application. And so we expect that the Supreme Court will take into consideration all these issues when dealing with the application.
Thank you very much, Madam. The Supreme Court was very clear in its ruling. It said that
I can't hear you.
I'm saying that the Supreme Court was very clear in its ruling. It said that a petitioner in an election petition case stands on its own strength, and not as the respondent's witness. Is that what you sought to do?
I didn't hear the last
I'm asking if that's what you sought to do. I mean, using the respondent witness to make your case.
Definitely not. We have the strength of our case, but as we have stated over and over again, the EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer. The petitioner does not declare results. It is the EC or the chairperson that declares results in presidential elections. Does that answer you?
My question is a follow-up to my brother's question. In giving their responses as to why the first and second respondents will not let their witnesses come to the box, the reason they gave was that the petitioner had not made a case strong enough to warrant them presenting any witnesses.
That's not what the Supreme Court, I didn't hear the Supreme Court say that.
Well, I would like you to give me your understanding of but that's how I understood it.
I never heard them. I never heard them say that.
That was what the lawyers, the lead counsels for the respondents, first and second respondents, one of the reasons they gave was that the petitioner had not made a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you as to what you understood.
As simple. If we disagree.
Well,
as simple as
because then my question then would have been...
You heard counsel for the petitioner on Monday. And we disagree with that position. That the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. None of the two candidates got more than 50% of the valid votes. There's only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any gazette notification dated on any of the purported corrections, the dates of the purported corrections? There is only one, 9th December, and the CI 135 talks about a declaration of 9th December.
Okay, so then, Honorable, if the petitioner does not get the chairperson of the EC to respond, does that then make your case a dead case? Because you seem to be insisting that she must, by all means, respond to certain questions.
And we will insist. We'll cross that bridge. But I believe that the petitioner has made, we are convinced the petitioner has made a case.
Well, so the question is, if you are very sure in your case, why then the insistence on the EC entering the dock? Why would you not just allow the court to rule on what evidence has been availed to it so far?
I can't hear you.
I was saying that if you believe in the petitioner's case, why then the insistence on getting the EC, the chair of the EC, to enter into the dock? Why not just allow the court to rule on what matters has been brought?
Allow?
I am asking why the insistence on getting the EC to enter into the dock to be cross-examined. If you are sure about the petitioner's case, why not just allow the court to rule on your case so far, since the respondents are withdrawing from?
That there are questions that we put to her that only she can answer. Nobody else can answer. Irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending, or you're not depending on the witnesses of the respondent.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you're not even expecting the witnesses to make your case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. Yo, anyone? I mean, say, and your bar court etc. No, as someone at the court and impa.
Well, we had Marietta Brewer-Piaupong, a member of the petitioner, Mr. Mahama's legal team, one of the spokespersons addressing the media. Again, they disagree with today's ruling, and she talks about two applications that their lawyers are filing in court just today after the ruling. One is a review of this morning's decision on the issue of whether or not to compel the EC's witness to mount the witness box. They are also applying to reopen their case since they closed it after their third witness testifying in their favor. Then there's also the issue of the subpoena. So these are the two actions that they're quickly taking in court today. But of course, she touches on many things, and the journalists there also ask very crucial questions. I guess one of the questions has been, why do you insist on having the EC chairperson in the witness box if you insist that you have a strong case?
Indeed, and her response, as you heard, was that there are certain questions that only the EC chair can answer. I mean, if I was there, I suppose my follow-up question to that would be, well, if there are certain questions that only the EC chair can answer, does that not mean that your case depends on the EC chair's testimony? If there are certain questions only she can answer, what happens if those questions don't get answered? Does it affect your case? Does it affect the strength of your case? If it does, then doesn't that mean that in fact you are depending on the EC chair to make your case strong? So yeah, fascinating exchange there, but nothing surprising. I did find it interesting. Madam Marietta described the
wishy-washy.
Yes, wishy-washy and
superior arguments from their side in terms of the arguments. Chachi Chikata made, Mr. Chachi Chikata made on Tuesday.
Yeah, very interesting use of words there, because the suggestion here is that I made a superior argument, or my side made a superior argument, your side made a wishy-washy argument, but the court ruled in favor of the wishy-washy argument. So you heard one of the journalists asking her, what does that mean? So in that case, what is your view of the Supreme Court's decision? If the Supreme Court is making a ruling in favor of a wishy-washy argument, when there is a superior argument available, what is your view of the ruling there? I mean, she skirted that very nicely by saying, look, we respect the decision, but we don't agree with it.
Absolutely.
Fascinating. I don't want to call them revelations, because none of this is a revelation, but submissions, I guess.
I think we had all explored the other sides, coming into today. We had looked at what if it goes in favor or against, and the parties themselves had played this all out really well. Yeah. So we're all familiar, except that I think when the thing is hitting you, you take it differently. We see the other side also getting ready. Kojo Ponkoma, one of the spokespersons for Mr. Akufo-Addo's legal team, ready to talk to us. Let's listen in.
Colleagues, good morning. I think it's been one of the shortest days in court so far. We have some remarks to share with you. I want to start by quoting about 3 or 4 things that the Supreme Court of the Republic of Ghana, speaking through His Lordship the Chief Justice, put out today. First is that the law is settled, that a party cannot be compelled to adduce evidence under the circumstances that we are discussing. The law is settled on that matter. And you notice that the Supreme Court spent some time to educate all of us who are interested in the legal profession or are following this case on the various cases in times past when the courts have ruled, sometimes up to the Supreme Court, that is the position of the law. Nyamiche versus Ansa, Bamo and Labi, Te and another, AMA and Hydrofoam Estate Society of Lawyers, they went at length to remind all of us that on several occasions, the courts have had to lay down this rule and that the law is settled. So if anybody comes with some new arguments as though it is a gray area of the law or that it is possible to compel a party to come and adduce evidence in circumstances like this, the law is settled, that cannot happen. The second point that the Supreme Court has made, which I think is very important for us, is that a case is won on the strength of the plaintiff's case and not necessarily on the weakness of the defendant's case. A case is won on the strength of the plaintiff's case and not necessarily, even if so, on the weakness of the defendant's case. So this suggestion that the defendant, or in this case the respondents, must mount the witness box to enable the petitioner complete or strengthen or make a case is contrary to what the law and the practice has been for all of these decades. The third point that the Supreme Court has made today, that it has heard all of these arguments about she holds a constitutional office, the EC is a constitutional creature, and therefore there must be accountability. You remember that even for us speaking to you last week, we said if you want accountability, let's all go to Parliament, whether it's Public Accounts Committee or a parliamentary inquiry or something. But when you come and you apply to the court under some specific rules, you don't fail to meet that standard and then resort to that general argument. The court has said something about it, and I think we need to take note of it. It says that the fact that she holds a constitutional office and that there's a constitutional responsibility involved does not mean that a different set of rules must be made up. Now, I think it's very significant that the fact that she holds a constitutional office or that there are constitutional responsibility questions that are being raised does not mean that a different set of rules should be made up. So today, the question that the court invited us so that it will answer, whether or not a party can be compelled to adduce evidence, the court has answered it and has given the many instances in which it has arrived at this similar position. Now, you remember that our colleagues on the other side opposed our statement to the court that we were closing our case. And please let me just take you back. They made their case and closed their case. When it was time for first respondent said that first respondent was also closing its case and did not intend to invite anybody to adduce evidence. And that closure took place. Second respondent did same. So all three sides have closed their case. That was when they objected that we cannot close our case and they cannot close their case until they bring in the EC chair to be cross-examined. And they opposed on three grounds. That they are of the view that she has already elected, or the EC has elected to adduce evidence. And you heard the long submissions that were made, even our colleagues who came before you tried to make a new case that election happened when the court gave orders for the filing of witness. Today the court has settled that matter, that is not true. The court gave an order that we should file witness statements. We even complied. They did not comply. The court had to give them leave to come and do it a second time. Compliance with those orders does not amount to election to adduce evidence. The court has settled that question. This other argument was made that because of some of the averments in her affidavit, it amounts to evidence in the substantive matter before the court. The court has explained that the affidavit in interrogatories does not amount to evidence. The affidavit at the interlocutory level does not amount to evidence in the substantive matter. And I think it's a major point of law that all of us who are following should now follow. And I think this conversation of constitutional rule and accountability has been dealt with. Now, the Supreme Court has also reminded us of the threshold of what an election petition has to be. You heard the court speaking through the Chief Justice refers to the ruling of 2013 that the party petitioning must show that A, not only were there violations, but the said violations affected substantively the result of the election. And that you have to establish this. It is after you have established this that the burden of proof shifts to the other side. And that you stand or you fall on your own case. And then very finally, you notice that the court was at pains to point out that sometimes some of the cases we have been citing are of no moment to the matter before the court. Sumaila Bill was raised. The court said it's of no moment in this matter. It has to be distinguished. Remember the last time they cited Elis Tamaklo. The court said it's of no moment to the matter we are discussing. So we think that it is important that some key attention is paid to some of these issues. Right now where we are is this. The petitioner who petitioned the Supreme Court that nobody won the election and that he has 5 witnesses to prove that nobody won the election. He's called 3 of the 5 witnesses and in the end has closed his case. The first respondent said, I don't have any witnesses who I think have to respond to this supposed case. And so I don't intend to adduce evidence. So I close my case. Second respondent has said same and has closed its case. And now the court has given orders for when we should bring our written submissions. Our lawyers have started working on that. We hope to meet the deadline that the court has put out. The petitioner is now informing the court that he intends to come with an application to reopen his case. Of course, that application to reopen the case and cite new evidence comes with its own legal threshold that they have to meet. And that if they are successful at that, then they'll be coming with another application intended to subpoena the Electoral Commission chair. That also has its own legal standards. We find it curious that for a petitioner who claimed to have evidence to make their case, and who was not stopped in any way from calling all 5 witnesses, called 3, you saw how the 3 performed, whether or not they addressed the issues before the court, and was not forced by anybody to close his case, was not directed by anybody to close his case, voluntarily announced to the court that, my lords, we close our case is done. We have closed that. We've made enough of the evidence that must be made available to you. So our case is done. Now is telling the court that he wants to reopen his case after the court said you cannot use the first respondent to make your case. And they are even signaling that if they are successful in reopening the case, what do they intend to do? They intend to subpoena the second respondent. Why? To come and make their case for them. Sorry, the first respondent to come and make their case for them. It is becoming clear, particularly to the NDC supporters across the country who have been believing everything they've been saying along the line. First they said they won, then they changed it to they didn't win. In the last 1 week, right before you, they've been changing the argument that it's a constitutional accountability matter. And it's not so much about who got 50%. My learned senior Dominic Kayine has been saying that before you every day. That is a constitutional interrogation that they need to do. And that is it's a constitutional matter. 3 different cases. They keep changing the goalpost. And that is why you heard the court, I think, refer them to the basis on which we're here. So we continue to say that we're in the hands of the court. We will bring in our submissions by the deadline and pray the court to dismiss this petition before it. We'll take your questions.
Okay, so Mr. Minister Designate, I'll ask the first question. My name is Wilberforce Asari. I work with Asasi Radio. When the Supreme Court started its ruling today, it started by quoting Article 64(1). And it says that this whole case is about this article. We've been in court for 14 times, and we've been hearing that this case is about so many things. Why is the Supreme Court saying that this case is essentially about 64(1)?
I will borrow the words of my learned senior Dominic Kayine. I think somebody asked a similar question a few days ago, and then he said this is not a debt collection matter. You recall? This is not a debt collection matter. And that this is not a case between some plaintiff and defendant. It's true, he's right. But what it is that this is a challenge to a presidential election under Article 64(1). And the court has explained what that animal is. That you come before the court and you say, my lord, I'm challenging the validity of person X as having been elected as president-elect and therefore president of the republic. And the Supreme Court has explained what you must meet. The point the court is making is that that is what you came to tell it in the beginning. And therefore, all these proceedings are supposed to be within that confine. They are therefore looking out for the evidence you adduced to make that case. Not this new afterthought argument of accountability, constitutional responsibility that is being made. Accountability, constitutional responsibility is not Article 64(1). It's not, respectfully. Article 64(1), under which they came, is to challenge the validity of Nana Addo Dankwa Akufo-Addo having been elected as the president of the republic. But as I mentioned earlier, you notice that they keep changing their position. We won. We didn't win, but nobody won. Now they say it's about constitutional and accountability matters. And to the NDC supporters in particular, your leaders are continuously changing the goalpost and are not meeting the evidence thresholds and standards that they have to meet in. So if the Supreme Court goes back there, we think they are guiding all of us that this is why you people claim you came to court. Let's stick within that confines.
Thank you very much. If the action of the petitioner succeeds in court, i.e. leave to subpoena and application to reopen case, would you as second respondent be compelled to also ask for leave to reopen your case?
Well, there are a number of options that are out there depending on the court's rulings as they come. We are of the respectful, humble view that, as the court said today, the principle is that you cannot compel a party under these circumstances to adduce evidence. Even if you prove some fresh evidence and extreme circumstances under which your case should be reopened, and then you come with your second application for subpoena, what is that subpoena supposed to achieve? To compel the person that the court has said cannot be compelled to give evidence. The subpoena is now to compel that person to come and give evidence. We think it will be an interesting set of arguments. But wherever it goes, as we have said, if it becomes necessary that we put witnesses in the box to respond to issues, we are more than happy. I keep telling you that Chairman McMahon, who comes here every day, prepared that if they cross a threshold, then we have to do that. We'll do that. But as you have noticed, unlike the petitioner who, as some of my colleagues have been suggesting, appears to be abandoning the case because he's been here twice, we are always here. If it becomes necessary, we'll be happy to mount the box. But now it's also becoming clear why we filed a submission of no case. Because on the face of the petition, it was, the preliminary legal objection, okay, that this is not an election petition properly so-called. It was clear on the face of the petition. And that is why we put in that application. Perhaps if we had even struggled to go and put in witnesses, we would have been undermining that submission. That submission is still before the court for the court to consider. And so, depending on what the court decides to do, our senior lawyers will take, their next line of action. Indeed, I have heard conversations. I don't know if I have their permission to say this. I've heard conversations by some that if they elect to subpoena the EC chair, maybe we should also elect to subpoena the petitioner to be brought into the box. I don't know if they will agree to it at the end of the day, but it is part of the various, conversations. We'll see how it goes. Yes, sir.
Based on where you have just landed, are you worried by the application coming up? Again, we have indication that there's going to be an application for review on the ruling given today. Is your side worried about these two pending or impending applications?
Well, generally, as a lawyer going to court, you must worry about the possibility of some part of the law that you haven't cited, which could be used to undermine your case. And in all humility, we will also re-examine and look at whether or not there are some parts of the law that we haven't exercised our mind to. But the law as we know it now, which the Supreme Court has announced that it is settled law, does not tell us to worry. All the cases they cited, the authorities that they put out there, they do not tell us to worry. But in all humility, we'll look at our books again to see perhaps if there's something that we missed. But we are still in the hands of the court. Colleagues, thank you. My colleague Nanabi would translate.
Abusuafo yadamwase. Ene eka ho a ene dey
Kojo Ponkroma there, he is one of the spokespersons for Mr. Kufuor, legal spokespersons for the second respondent, Mr. Kufuor, in this 2020 petition. One of the things Kojo says is how they're curious that the petitioner, after closing his case, intends to reopen after the court overruled their objections or the objection of the EC chairperson mounting the witness box to give evidence. If they indeed say and they still believe that they have a strong case. So we're going back to the same issue, Kojo, of if they have a strong
from that. Anyway, the point that I'm trying to make is that something occurs to me from what Mr. Opoku-Nkrumah has shared, but I'm also arguing against the same observation that I'm making. So he was asked a question about the
subpoena.
The subpoena, right? And Mr. Opoku-Nkrumah says, well, he finds it difficult to imagine a situation where right after ruling that a person cannot be compelled to take the stand, the court would then grant a subpoena for that same person that they've ruled is a legal process. A court can grant a subpoena,
which is quite separate from what
they just ruled on, which is that a witness that has been offered by a party, if that party then changes their minds and says, I'm not going to offer this witness anymore, can the court compel them to reverse that decision? And they've said, no, we've looked at it and the court cannot do that. So they've ruled as such. But I don't know how that affects the granting of subpoenas. To my mind, it should be a separate thing. But as soon as I said that, then I started arguing against myself. Because, I'm not a lawyer. Again, let me make this very clear. But everything I've read about subpoenas suggests to me that they are designed for the bringing of perhaps disinterested parties.
Some say hostile witness.
Right. So a person who is not necessarily one, either the petitioner or the respondent, a person who is neither of those parties, could be brought in by subpoena to testify if it is believed that their testimony will, in one way or the other, advance, the judgment of the case. But in this case, can a subpoena be issued against one of the parties? You understand? If I'm in court against you, can I use a subpoena to get you, who is an interested party, into the box if you don't want to testify on your own behalf? Can a subpoena be used to compel a party to testify? You know? And that's something I'd love to get some education from our lawyer friends on, because it kind of mitigates against my own observation there.
Yeah, I mean, me too. I understand why that's playing out in your head. Because usually, you know, the lawyers would say it's when you call a party to testify or to give testimony and the person is unwilling. But these are very different scenarios playing out here. So it will be good to raise, hopefully, something Ladia back on so we can put some of the questions you know, to him and try and get some answers. But if you missed what happened this morning, today's ruling, of course, we've endured the long hours. Some people thought that this was also going to travel many hours, but we did it just in an hour, really. And the courts, first of all, in a unanimous decision, overruled an objection by Mr. Chikata as a result of the EC's decision to also close its case and elect not to put its witness, Jane Mensah, in the box. The court says respondents cannot be compelled to give evidence, essentially wrapping up the case on it. Now we know that Mr. Chikata is in the process of filing so that the case can be reopened because, as you know, he closed the case after Roger Metal Nunu's witness statement, or no, after he gave witness and was cross-examined. We also know that they intend to apply for today's decision to be reviewed, and then they intend to subpoena the EC chairperson, returning officer in the 2020 elections. The court has set February 17 for all parties to file their closing addresses, and the court has also adjourned sitting to 18th of February for the lawyers to make their closing addresses as well. And then we'll look forward to judgments. But the court says that it is open to all the applications that Mr. Chikata intends filing. Well, we have to wrap up on this, and we have to go to Parliament because it started vetting ministerial nominees yesterday, and they're continuing today with the Minister Designate for Defence appearing before the committee. Vetting today is being done in the main chamber of Parliament.